Yeah. Hi, everybody. I'm Ed Reitler. Thank you for tuning into our webinar on the Payroll Protection Program. I'm sure you've been reading a lot about it, hearing a lot about it. Like so many of us, we're getting information in real time. And we wanted to try and have a program where we could hopefully provide you some answers. I think we've got a great panel today that will take your questions at the end of the session. And hopefully help guide you in the process of whether you or companies you're working with can apply to the PPP. So as you know, the Payroll Protection Program was enacted as part of the CARES Act a couple of weeks ago and has just been rolling out as part of the Department of Treasury's efforts to help small businesses, those with less than 500 employees, meet the challenging circumstances of the COVID-19 pandemic. And I want to just begin by saying I hope all of you are safe and well, and your loved ones as well, and that you're in a place where you can at least get outside and get some fresh air. In the Northeast anyways, it's a pretty nice day, so I hope you've had a chance to get outside and take a break from all of the stress that comes with working and learning remotely. I want to just say a few words about our firm. Many of you know us. I think most of the people who have registered have worked with us or otherwise friends of the firm. We are a Reitler, Kalis, and Rosenblatt. We are a 40 attorney firm. We've been around for our 25th anniversary. And we represent around 225 active emerging companies and around 40 venture funds. So as you can imagine, we've been getting a lot of questions about the PPP and how it might apply to our clients and other friends of the firm. The firm also has something called the Reitler Advisory Group, which is a wholly owned subsidiary. We use our advisory group to help our clients around the capital formation process. Their services are free. It's paid for by the firm, and it's part of a business acceleration program that we offer our clients. And primarily they help with fundraising. And within the last 2 weeks, they've really leaned in and learned as much as they could about the PPP. And we have one of our advisory members who is a real expert with SBA lenders. And as I mentioned earlier, the program is being administered by SBA lenders. The SBA is not distributing the funds directly. They're using banks to wholesale the money to get out to the small business community. And some of our panelists will talk about exactly how the banks are incented to do that and what is happening in real time at the bank level on a commercial basis. So with that, I'd like to introduce our panelists. As I mentioned, I'm Ed Reitler, and I work in corporate finance and M&A at our firm. My partner of over 20 years, Scott Rosenblatt, also works in those same areas, and he and I both have been leaning in on particularly the affiliation rules that affect venture-backed companies as far as their eligibility for the PPP. And then Terry Ho, as I briefly mentioned, our advisory group. Terry is a longtime private equity investor. I first met Terry and started working with him in the early days of our firm in the 90s when he was working at Paine-Webber, doing a lot of balance sheet investing in strategically aligned companies for Paine-Webber in the fintech space. After Paine-Webber was acquired by UBS, Terry joined Lightyear Capital along with the former CEO of Paine-Webber, Don Marin, who sadly recently passed. Terry worked at Lightyear for 20 years and was an investor in several SBA licensed banks and got to know a number of banks and their executives, including the CEO of Dogwood State Bank, which is a North Carolina chartered financial institution. And so from that bank, we're fortunate to have Chris Kwiatkowski. He's the president of government guaranteed lending at the bank, and was prior to that the director of government guaranteed lending for First National Bank, following its acquisition of Yadkin, which was a portfolio company of Lightyear, where Chris got to know the team. Prior to Yadkin, Chris was at, or I should say Terry got to know the team. Chris was at SVB of governmental guaranteed lending, following the merger of Vantage South Bank Shares and Piedmont Community Bank. So he has a deep, abiding knowledge of how Section 7A, which is the statutory section under which the PPP is being administered under the SBA Act of 1958. And I know that Scott and I and Terry have really leaned on Chris a lot when we had questions or our clients had questions this past week. So Chris, I know you're really busy and you're up to your eyeballs in dealing with applications. So we are very fortunate, and we just want to say thank you for being with us today. And before we get into the actual agenda, I just want to note that we've already received some questions from some of the attendees in the webinar. You can do so by going to the bottom of your screen and clicking on the Q&A tab and submitting your questions, and I'll take them, provided I can figure out the technology before the session ends. We'd like to wrap this up by 5 o'clock, so hopefully we can get to Q&A, but we'll try and get through the agenda to make sure that the basics of the PPP are covered. So first, I'd like to start with just an overview of the PPP and a summary of the loan terms. You can see, should see it on your screen here, and I'd like to have Chris, why don't you take that away and just walk us through what exactly are these loans, what is forgiveness, and how much can be borrowed, who's eligible?
Absolutely. Thanks, Ed. I appreciate the introduction and happy to be here with you today to talk about this payroll protection program that is being administered by the SBA. I know you've all heard a lot about it, and we've been waist deep in it since last Friday. So just starting at the top of the page here, you can see when can you apply? Well, it started last Friday and it runs all the way through June 30th. So if you apply, if you get an application in June 30th, you're still eligible for this program. And what you should know about the program, well, currently $349 billion has been allocated for this program via the CARES Act. You all may have heard recently that the president, as early as last night, said another $250 billion may be heading the way of the payroll protection program. That hasn't been finalized yet, but we'll wait and see, because it has been a very popular program very early. There's been a lot of interest in it and a lot of money being secured via the SBA's electronic transfer site. Who can borrow? Basically, it's small businesses with less than 500 employees. You can also default to the banks, to the SBA's regular size standards via the North American Industry Classification System. But to make it simple, they said businesses with 500 or less employees. There are some limitations with startups owned by venture capitals, depending on when the company was formed, et cetera. And we can talk about that. But if you were in business prior to February 15th of this year, you may qualify for this program. This program is based on a loan being forgiven. But if there is a loan after the time of forgiveness, it will be at a 1% interest rate over a maturity of 2 years. The first 6 months will be deferred. Principal and interest will be deferred. Interest will accrue, but it is deferred for the first 6 months and then most likely amortized over the following 18 months, excuse me. Loan repayment can be extended 6 months. Interest accrues, as we said, no prepayment penalties at all on this. But I think the goal of the program, obviously, is to have loan forgiveness, and that is a tax-free event, which is, I've never seen anything like this in my 27 years of SBA lending. So it's quite interesting times to be in this industry. The amount you can borrow is two and a half times your average payroll. So you go back to 12 months, figure out what your average monthly payroll is, and then roughly 2.5 times that is what is the loan you are eligible for. That is capped at $10 million, so the loan amounts can go up to $10 million. Our bank right now has about 400 applications. We're averaging about $450,000 per application, so it will vary. The compensation, so when you're figuring out the monthly payroll, individual compensation is capped at $100,000. So for those higher paid employees, you can take their salaries up to $100,000. You can take benefits beyond that, add that to the $100,000, but anything over $100,000 is not counted towards the calculation. Let's see, so that goes on and tells you about the benefits, et cetera. It does exclude contractors 1099. If you do pay contractors, you cannot count them towards your payroll calculation for your loan. Those contractors would apply for this program themselves, and that program opens up for them starting this Friday. You must certify that 75% of your payroll protection loan will be used for payroll. Obviously, the government's whole premise here is to keep people employed. So while you can use 2.5 times your average payroll to figure out your loan amount, your forgiveness is based on the following 8 weeks after you receive your loan. And then it has the eligible costs for forgiveness are payroll, are rent, utilities, and mortgage interest. So you can put all of that into a formula to figure out your forgiveness, but no more than 25% can be non-payroll expense. Again, the government is really trying to make sure this is about job preservation. Upfront fees, there are no fees paid by the borrowers at all. So the lenders do get paid a fee directly by the SBA based on the loan amount, 5% up to 300, loans up to 350, 3% fee on loans over 350 to 2 million, and loans over 2 million up to 10 million get a 1% fee, again, paid directly by the government. Nothing is charged to the borrowers. If a packager or an agent helps the borrower complete the application, that agent cannot charge the borrower again. The bank can pay the agent, but the borrower pays nothing in this. So it's again, that's the mantra of the SBA, protecting small businesses, protecting the borrowers. Affiliation rules. I know that's going to be talked about a lot later on in this presentation. Those are something you need to pay attention to, and I think I can leave that for later on. But basically, again, it's 500 employees per business, except for those NAICS codes starting with 72, which are food services and accommodations. So really hotels and restaurants. Those can have up to 500 employees per location. So those are exempted from the overall 500. So that's something to keep in mind. Let's see, forgiveness calculation. I mentioned that earlier. It's the 8 weeks of payroll following the funding of your loan. We are just finding out that from the time that a lender secures your SBA number, if you will, for your loan, the lender has 10 days to close on that loan. And then after those funds are dispersed to the borrower, the clock starts for the 8 weeks of forgiveness. So that needs to be kept in mind. And again, only 25% of that forgiveness calculation can be for expenses outside of payroll. The documentation you need to provide. We will, as a lender, verify everything, but it's going to be your usual suspects along tax returns. It's going to be IRS form 940, 941, things such as that. So we can verify your payroll. That can come from a company like an ADP, et cetera. As the borrower, you're certifying that that is your payroll. We will look into make sure that obviously that makes sense in our purview. It is you're certifying as the borrower when you sign this application that you're obviously getting the loans based upon payroll, and your forgiveness is based upon eligible funds, and you're using the loan proceeds for the purpose of the program, which is to retain employees. The SBA says they will come after you if they find out that you did not use the funds properly. That remains to be seen exactly what that means.
Thanks, Chris. That's a very helpful overview. I just want to reiterate that the big thing, and Chris started off, it's such a massive program, and it's a giveaway program. If you follow the rules of the program, it's a forgiveness program so that these small businesses can actually keep the money. They don't have to repay it. And that's remarkable. It's a remarkable idea for Congress and the administration to support the small business environment. And one thing that he ended with, which we're going to touch on, especially in the affiliation rules, is that the banks may not be able to do all the due diligence here on some of these eligibility requirements. And there may be, at the end of this process, an audit cycle that the SBA goes through, especially if there's pressure on whatever administration is placed at the time to account for how the funds were expended, especially if there's stories of fraud that come up. So it's important that that you provide adequate documentation, and we're going to touch on that in a little bit. So we'd like to cover what banks are doing right now. And I think Terry and Chris can both cover this to get a sense of what's actually happening in real time this week.
Yeah, hi, this is Terry. Chris, if you're okay, let me just go down to the banks quickly. I've been going on their websites and also talking to clients who've been applying to these banks. So just wanted to give you a high-level overview. And Chris, you also know a lot of these banks personally, so please feel free to add any comments. So B of A was the first bank on Friday that opened its doors and did it in a massive way. They've already lent over $34 billion as of when they reported that Monday. They've been very active you know, are putting a lot of resources. We're able to open their website quickly. All banks are trying to tell their clients that they are giving preference to their borrowers and then to their depositors, and so you should be aware of that. Some banks are not up yet. So also at a high level, please do not give up trying. Your banks are trying to roll out their program, but some banks have not yet done that. Chase Bank opened up also on Monday, and they delayed it for non-borrowers. Right now, if you're a depositor and have a borrowing account, you're probably active. If you're not a borrower from them, but are a client, they're probably trying to delay you. They're giving you information, but are rolling out access. So they're just getting overwhelmed as well. Citibank has been behind everybody else. As of today, they just opened it up to a very select number. They're trying to do it randomly as well because they're trying to not overwhelm the system. But they literally just opened up their website today. We added Dogwood. You've heard from Chris that they've been very active and already have processed over 400 of their clients. We've reached out to several non-bank lenders. So Fountainhead is a non-bank SBA lender. They are based in Florida and will take applications. And so afterwards, if you reach out to your Reitler attorney, they will, and if you need to find a bank other than your banker, will pass information on about Fountainhead. But our view is you should continue to try to apply through your bank. First Republic Bank has accepted applications, have said we're not yet ready to open up their website. As of yesterday, had not opened their website, but has said, here are the documents we need. Here's the SBA form that you need to fill out. Please send all of this to us, to our SBA COVID email address, and we will start processing. Once you've gotten that, you should receive an email saying they've looked at your file and are starting the processing of your loan. PacWest has not yet opened their website. They're probably behind other banks, and you know they're probably a very important name for you. Silicon Valley Bank just opened their website yesterday, and they have lots of details on what you need to gather in terms of information, and are in the process. And Wells Fargo has been very active. They hit a pause button. They hit $10 billion because they were under regulatory action that preceded a lot of things. This related to some of their behavior with their clients. They had a cap on their balance sheet, which their regulators just released them from this morning. So they're now, if you're a Wells Fargo client, you can now continue to apply to Wells Fargo. Chris, any comments on any of the banks or other banks you know?
Well, I would just say in general, keep in mind though, where this says Bank of America has processed $34 billion. I have not yet seen banks in mass funding these loans yet. They're securing the loans through the SBA's electronic transfer site, but I don't think you guys have all probably seen on the news, the money's really not flowing yet. This whole program was put together extremely fast and using the SBA as the vehicle to deliver it. SBA has never moved this fast. And every day we are receiving new information about the program. So it started Friday and the doors were opened up and people started reserving numbers. But to this day, we are still getting information on how to underwrite these loans, what to pay attention to, what's eligible, and how to close the loans. The SBA is just putting out an authorization. I got an interim, what's called an interim authorization last night that we believe will be the final authorization. But again, things aren't finalized. They're very fluid right now. And so banks haven't turned on the spigot yet. So small businesses haven't really started receiving any of this money at this point in time. So it's a bit tenuous. We want to get borrowers their money ASAP. We want to make sure we're doing it right as lenders. And we want to make sure that we're protecting the borrowers out there so they can get maximum forgiveness. Because as Ed pointed out, these can be totally forgiven like a grant. The SBA doesn't like to use the word grant, but these are like a grant that are totally tax forgiven if the formulas work out. So there's still some, the devil's in the details, to say the least.
Chris, have any loans been funded to date that you are aware of?
Not that I can verify.
Okay.
We hope to start funding tomorrow morning.
Oh, great. That's fantastic.
Yeah, we're excited about it.
Okay. Well, thank you. Let's talk about the loan process and how our advisory group might be able to help you get through this.
Yeah, and Chris, please feel free to chime in as well. The 4 steps. The first one is you need to make sure that you are eligible. And as we mentioned earlier, as Ed's mentioned, the key thing that may trip you up is that affiliation rules relating to your investors that are venture funds may trip you up and may make you ineligible. So we'll put that aside. We assume that you have looked at your ownership, your cap table, and your investors, and you've passed that. You then need to calculate the amount. Chris has hit on that. It is the payroll, which has been defined by the SBA as including compensation to a cap of $100,000, not including withholdings for federal purposes, but including withholding for state and local purposes. And withholdings for federal purposes also mean you don't include Medicare or other federal withholdings. And then, as Chris mentioned, you can add your benefits and your 401k and other pension benefit costs that you fund every year. That can be put into the formula. The time period is the last 12 months, so you're calculating it for April from last year through March of this year. You're calculating an average amount for your payroll. That's the amount you put in times 2.5. The form itself is available online. You probably should pull down the form, fill it out, and then your bank will tell you exactly what it needs. A lot of banks have taken the same questions on the form and put it on their online application. So they'll say, we don't need the form for you to upload. But the banks will ask you to upload other documents that Chris mentioned earlier, the 940. They may ask you also for your tax filings from 2018 if you don't have 2019 available yet, and other information relating to your business. And then you submit everything, and then once the bank has processed this, as Chris mentioned, the forgiveness process will be a bit more complicated. Banks do not know what to do yet. They're not focused on it yet.
Okay, great. Well,
you would like to add on that?
I think you hit on everything there. We hear, there's a bit of underwriting. We do ask for some tax returns. At the end of the day, if we are left with a loan, obviously we want to make sure that borrower is prepared to pay that loan. So every bank will be a little bit different in that regard, because just like the SBA's typical 7A program, it is our money, the bank's money that goes out the door, and the SBA guarantees it. So the bank is going to be hopefully prudent with their analysis, although it'll be very quick since their quote unquote is 100% guarantee on this.
Great. Thank you, Chris and Terry. So as you know, the statute, the CARES Act, says that this is really limited to small business, and they have the fairly arbitrary cutoff of 500 employees. And the issue has come up with regard to its affiliation rules as to whether any of the shareholders of these small businesses might trip that 500 employee limit by being affiliated with the applicants for the loans. And that's a particularly acute issue for any company, small business that's got venture funds as investors. Obviously, with a portfolio of 20 plus companies, the 500 employee limit's going to get hit pretty quickly. And so there's been a lot of talk and writing and thought put into these rules and how they might apply to venture backed companies and what might be done to help these companies become eligible if they otherwise aren't due to the affiliation rules. My partner, Scott Rosenblatt, has been doing an awful lot of work in this space, as have I. Scott, do you want to go through ways in which companies might be affiliated to venture funds? You're muted, Scott.
That's probably a lot clearer.
Got
So
it.
the goal is to stay under 500. So the first analysis would be if your investor group is just starting out and maybe they don't have that many portfolio companies, may not be an issue. But for the most part, if it's an institutional fund that's been investing in companies, you would generally start with the set of rights that each of your institutional investors have, so that you could determine if you're going to be affiliated not only with that investment fund and all their employees, but all the employees of the other companies they've invested in which they have these type of affiliation or control rights. So in front of you on the list is sort of the hot button lists of what the SBA would look for. The overarching theme is involvement in day-to-day operations.
And may I just editorialize, Scott, for a second? Obviously, as you might expect, a portfolio company would be affiliated with an investment fund, a private equity fund, to the extent that it owns more than 50% of the stock or controls the board of directors. Those are traditional definitions of control for an affiliate. You find those definitions in securities laws, and they apply in the SBA context as well. What Scott is now delving into is, well, what if the company is not controlled directly by a majority of the shares being held by a fund? Or what if its board is not controlled, the majority of the board of directors is not controlled by a fund? What you're looking at here are a list of protective provisions that would be could be problematic if they are in your documentation. So with that, let's go back to that, Scott.
Sure. Again, so as Ed mentioned, we're talking about what you traditionally think of as minority interest holders in your business, where you normally wouldn't assume they were deemed to control your business and you'd be aggregating with them. So with that, you need to analyze, and you need to work with your investors to analyze which of these rights fall into what the SBA would be looking at as indicia of what would constitute affiliation. So starting on the left side, if the investor has the ability to block a quorum meetings of the board or shareholders, which comes up in a number of ways, most commonly by simply requiring a number of directors to be present to have a meeting, and depending on how many director seats that investor has, just by pure numbers, that could be the case based on how many directors are seated. So that's a simple numbers equation. Then there's a few hot button issues, again, which deal with day-to-day control of the business. If there are controls over executive compensation terms, stock option plans, the granting of options, acceleration or vesting of those options, all of those are problems which need to be resolved. We'll talk in the next slide about best practices of how you can resolve those. Continuing on, a very common term is a restriction on the ability to pay dividends or distributions, which investors are typically concerned about with monies flowing out of companies. So you're going to see that in a lot of these transactions, and you're going to have to deal with that one as we describe. Changes to the principal nature of the business. Another very big hot button issue is control over budgeting. If the investor has a say over the approval of the budget, variations in the budget, major expenditures, or even small expenditures would be even a worse example. Also incurrence of indebtedness, because the ability to control indebtedness at the company level, any kind of borrowing or guarantees, or the granting of liens or security interests, obviously has a big impact on the day-to-day operation of the business, and those all fall in this category. The ability to hire and fire executives, decisions on real estate leases and purchases of equipment and capital expenditures. Many of the SBA rulings even include the bringing or defending of a lawsuit or an arbitration. It could extend as far as ability to control the changing of your accountants or your auditors. There are also some tricky provisions that we've been finding in day-to-day on this, where it seems on its face it wouldn't trigger it, but you need to be aware of. The best example of that is a very typical affiliates transaction restriction, where the investor would be able to have a say if the company is entering into a transaction with affiliates of the business, officers, directors, other shareholders, their relatives. Now, this is focused primarily because you would be tripping one of the other problems, which is dealing with the compensation, either cash or equity, payable to the executives. If you have this affiliation restriction, you need to clarify what's meant in there, that it's not deemed to control or restrict the compensation decisions regarding the executives. So this is not a comprehensive list, because you need to discuss it with your legal advisor, whether there's something which doesn't exactly check off this box, but based on the facts and circumstances of this company, could be deemed to give an investor a control provision. And the one thing before we go to the next slide I want to mention is, what do we mean by control? It's very simple to analyze. If you cannot take this action without the consent of that investor or the representative on the board put in place by that investor, that's what we mean by having a blocking position, and that's what constitutes one of these elements of control.
Great. Should we go to how we can fix these problems if we have them in our cap structure?
Yeah. So the goal is get below 500. So to get below 500, you need to figure out how many of these investors you're going to be paired up with, because the goal from a company perspective is to unaffiliate with those investment funds so that you're not dragging in all of the employees of all their other portfolio companies and the fund itself. So breaking these affiliations is the key part. This is measured on an investor by investor basis. So simply by having, let's say, 50% of the vote of a Series A investment group necessary to take a certain action is not determinative. You have to look at who holds those securities and whether somebody in that class has greater than 50%. Because if that's the case, that 52% holder, by not voting in favor of the action, can independently block the action. Now, if you have a much higher standard on something, let's say 75%, and you have 3 investors that hold 25%, you've got 3 issues you have to deal with as to that protector provision. So this has to be analyzed investor by investor and the relative rights they have in the documentation. And also keep in mind, this is through their equity holdings or through nominees that they have on the board who, while technically not the same entity as the investment fund, usually align with the interests of the investment fund and raise the same concerns to the SBA. So where are you going to go to analyze this? You need to look primarily in the charter, which is going to have the equity-based protector provisions, but you're also going to have to look typically in the shareholders agreement or in NVCA type investments in the investor rights agreement, where there's typically a provision called board matters, in which any designees from an investor group or groups might have specific actions to which the consent of their director is necessary for that action to take place. So how do you solve the problem? Let's say you analyze it and you see you've got a few of these. Well, rulings, when the process first began, it was a little unclear of whether you can simply defer the application of those restrictions until after the application loan process, or even after till the loans are paid back. Well, that's been fairly definitively ruled. The snapback or the springback provision is not going to work. And as far as the latest SBA Q&A and frequently asked questions reveal, what they're really looking for is either an irrevocable waiver, which means the investor simply gives up that right, or an amendment to the terms that the investor possesses, or investors, so that it's not going to apply to prevent those day-to-day actions. We give the advice that it's important to match that with an immediate irrevocable waiver until that amendment can go in place, because without that, and if it takes a while, for example, to gain the consents necessary to amend your charter, you're still in the affiliation status and you're technically still blocked from applying for fear of being affiliated with 500 more fellow employees through the portfolio companies. So again, to rehash, what you would want to negotiate with your investors is amendments that solve the problem. Now, from an investor perspective, they're quite concerned about giving up rights that they've negotiated at the beginning of their investment. So we found, both from an investor side and from success rate for companies not to request an out-and-out waiver of these important provisions, but to work with the investors to bring it to a level where there is no block. So again, if you happen to have a 50% or a 49%, let's use that as an example, holder, and there's a 2/3 vote necessary to achieve an action, you have a block position for that investor in that class. But if you lower that threshold for those particular items, not all of the protector provisions, down to only a majority, now that 49% holder does not have a blocking position because they would have to team up with another investor in order to block that action. Meaning the company could go forward with that action even if this one large investor opposes the taking of the action. And this can be applied also in the context of directorships. It's a little more difficult, obviously, if you only have one director from one investor and the decisions are governed by consent of that director. But in often cases, in later rounds of investment, you'll have multiple directors appointed. Oftentimes, those provisions say, before a consideration of these PPP SBA concerns, both directors from, let's say, a Series A group and a Series B group would have to consent in order for these actions to happen. Well, a common solution, if the investors are agreeable, would be to say either the A or the B director, or if there's multiple directors, 2 out of 3 of those directors, provided 2 of them haven't been appointed by the same investor. This would clearly state that no investor has a pure blocking position, which is really your goal. You need to analyze this so that no individual investor can block. If you have that block position, you need to then approach that investor and determine how big is the pool of investors through that fund and all the companies within their portfolio to which they have a common affiliation, because you're going to be grouped with all of them for that 500. Now, some funds have a lot of investments, so it's not practical to ever get those funds down below 500 within their group of portfolio companies. But if your company wants to apply for one of these loans, you need to work hard with that investor to come up with compromises so your company can disaffiliate from that fund. Again, it takes a lot of work, and again, it's investor by investor, so no one should be lulled into complacency to think if they solve it with one investor, they're going to solve the problem across the board. Ed, do you have other examples from what we've been doing with that you want to illustrate?
Well, maybe the one example, and then I think we should get into Q&A because we've gotten an awful lot of questions during this webinar so far. Is there's a qualification on the application. I was on a board call late last night where we were going through this, and Scott, I know I asked you about this, and you have some thoughts on it as well. One of the general eligibility requirements we haven't really touched on yet is that, quote, I'm quoting now from the application form, current economic uncertainty makes this loan request necessary to support the ongoing operations of the applicant. And I think a lot of us aren't quite sure what that means because it's new to the form. And there are examples of small businesses, particularly in the venture space, that are doing quite well, that have received recent investments or about to receive investments. And possibly the SBA in a subsequent audit could determine, I suppose, rationally that this loan wouldn't be necessary to support their ongoing operations. Let's say a company's funded with 24 months of runway. And so those are some difficult things that companies are grappling with, the boards are grappling with. And there's some wisdom coming around that, but I was wondering if you guys had any thoughts on that particular requirement in the form.
Well, I'll tell you from what I'm hearing in the marketplace, there's reluctance on the part of a lot of significant investors in these companies to make changes solely for the reason of qualifying for the PPP loans. So there are a fair number of investors who say, listen, if you can do it based on what you have now, or you can work out with other investors, then go for it, but they don't want to be involved in that. And one of the reasons is they're concerned that these companies, which are otherwise well-funded, are seeking to share in this pool of money. So what's important to determine is does the absence of this funding really affect the viability of the business and its ability to retain its employees? Let's keep in mind the main reason for this funding is to maintain payroll and to keep people employed through this difficult time. So those companies need to resolve at a board level whether or not without this funding, it would be jeopardizing their future operations as a whole, which would jeopardize the employment of all the employees, or even some portion of the employees, because the general sense is that if you'd have some portion of layoffs, if not for this financing, then it's serving its purpose and you're meeting the goals and that certification.
So yeah, I would just also add to that the board discussion around those points, such as the uncertainty, would the uncertainty lead to, from the crisis and the economic impact of it, lead to reduction in payroll or cessation of operations of any part of the company? And that discussion should be documented. The minutes should be taken by preferably an attorney. And for those of you out there who face this issue, you should be getting counsel to attend that meeting and give guidance around that process, because there's a lot of uncertainty there about whether a company really needed to take on that capital if it's been recently funded. And you should certainly be talking to attorneys about a process to put in place to make sure the board adequately went through what the SBA is hoping it would consider. So with that, perhaps we should turn to questions. We only have 15 minutes left. We'll start with some of the questions we got before the webinar. And this would really be for Chris and Terry. Questioner number one is about freelancers. And he or she is asking that they may ask freelancers to apply for the PPP on their own. I guess freelancers servicing the company. Since freelancers can now also qualify for unemployment payments, what is a reporting requirement for the PPP program? Do they need to show that they're continuing to work for the original companies from earlier this year?
I would say no. I mean, I would say it's based again off their past 12 months history. And you would take that and figure out an average monthly amount, and then apply, that would be used, that multiplier of 2.5 times, and that would be the loan you would apply for. Because you're being affected by COVID-19, it can affect your ability to get new work. So you work, that's why they're saying go back on the historical schedule.
I would add also that getting other programs, whether it's the SBA disaster loan or at the state level, does not prevent you from being eligible for this loan. So the SBA is not looking at your other sources of potential funding during this crisis.
Great, thank you. The next question is, can an LLC that has owners or founders operating the business but doesn't have any employees file for the PPP? And then they go on to be more specific. The two owners take periodic distributions from the profits of the company, but don't pay themselves a salary or I guess a guaranteed payment. Can that entity participate in the PPP? And if so, what documentation should the company submit along with the application? Should it submit a federal tax return for the business and the owner's individual K-1s?
I'll take that. The prevailing thought is yes, that they do qualify and they would do exactly that. Look at the tax returns and the K-1s from 19, or at least the financials if you don't have your tax returns from 19. And as long as they're paying the taxes, the Social Security, the Medicare, that they would qualify under this program. As I said, information is still coming out, but we've been able to, at this point say with good guidance from CPA firms that they would qualify.
Great. Next question. If someone's an owner in more than one entity that wants to apply, does that foreclose a second entity if one has already applied? Does it matter the form of entities, LLC versus C Corp?
I think that you're on to the affiliation there. If you have controlling, if you have controlling power over that entity, they may limit you to the $10 million or the 500 employees. So if you have multiple businesses and your total businesses don't add up to more than 500 employees, or you don't apply for more than 10 million, I believe you would be okay. And I know that's a very broad statement, but I think you're okay.
And that's going to come up in the form. One of the questions, I think it's number 3 on the generalized form, asks about 20% ownership in other companies. So Terry, you might have some insight into what's common disclosure and what that question's about.
So from going through the affiliation analysis is what you have to do. We have been recommending that borrowers seek guidance from their bankers, but telling them that if you're above 50%, it's definitely an issue, as we discussed earlier, in that 20 to or other range where you have control, then you really need to speak with someone who can help you on the legal side. Chris, what else would you add to that?
No, I think you're right on the money there. It's a gray area that you should seek advice for.
And that's the one area on the application where they ask for additional background, and each of the applicants have been adding in disclosures, particularly in the context of investment funds that hold more than 20%. They're asking for disclosure on background on those parties and potentially who else is controlled by that party, so they can, I presume, audit on the 500 number.
Thank you. So the next question comes from David, and he says he's a founder who owns 25% of his company, but that 40% is owned by a company that's non-US. All employees work in the US. I assume he's asking, could that company apply for relief?
I'll jump on the ledge there. We had one similar recently where the owners of the company were Italian citizens, but all the company was in the US and all the employees were W-2 employees located in the United States. And we came back with the opinion, yes, they would qualify because this is the payroll protection plan, and those employees are US citizens here in the United States.
Now, I'll add a little more color to that. It may be relevant to this or may be relevant to others on the webcast. Foreign companies with US subsidiaries and US employees, or foreign companies with US employees, all fit the bill on that. And when you come to testing the 500, the advice that we follow is you have to include all the employees, whether those employees are in the US or not, in determining the 500 for affiliation purposes. So you can't simply use the 4 or 5 employees in the US if it's a larger non-US company.
Okay. The next question, I think Chris touched on earlier, some aspects of this. Chris, is there something more to add? I welcome your input. I have an LLC where owners aren't typically employees, but members. They have guaranteed payment structure rather than draws, meaning it does not look like regular salary, even if there's not technically payroll such draws. Would they qualify? Could they ask for relief under the PPP?
Again, I believe they can, yes.
Lily asks, is a payroll amount of $100,000 annualized or aggregate?
Annualized, as far as I know.
Next question is, when you have to list affiliates, I suppose, on the application, do you have to provide full financials for those parties?
I would say it depends on your lender. You know, every lender can ask for something different, so it could vary from lender to lender. I'll have to leave it there.
I'll add a little color into that. I haven't come across the issue of the requests for our full financials, but you're certainly going to have to list some details on your investors if you have institutional investors that haven't unaffiliated. And then the question comes down to whether or not those funds need to disclose other companies for which they're affiliated. And that's been somewhat of a sticky point. Investors are somewhat reluctant to generally disclose that information.
Thanks. Lily asks, can you add state and local taxes on compensation on top of the $100,000 salary cap?
Yes.
Next question. What is the standard for being able to determine if they can repay the loans? How does cash flow positive versus still being venture funded impact all of this?
The repayment, the forgiveness is based on expenses. So it's based on the next 8 weeks of expenses after you receive the loan. So cash flow positive really doesn't come into that factor It may, with your individual lender, the lender may say, even though it's 100% guaranteed, that we're not comfortable making a loan to a non-cash positive company. But as far as forgiveness goes, it's based totally on the expense you incur in the next 8 weeks afterwards that qualify towards the forgiveness.
We might want to add that this is the Payroll Protection Program. So obviously you don't want to be terminating the employees that you included in your estimates when you took on the loan.
And also, if you have terminated employees, Chris, you've seen this as well. If you have terminated employees, the goal is for you, after you get the loan or as you get the loan, as long as they are on your payroll and you are paying them on the forgiveness side, that will also qualify.
Correct.
Our next question comes from Tim. Hello, Tim. And this is an area of if the SBA audits the program, would this be an issue? The company has salaries of founders who both have large equity stakes. Do they count towards the payroll calculation?
I would say yes. Again, it goes back on a historical basis. If they had payroll, if they were paid in the last 12 months, and that goes into the average monthly calculation. So yes.
And Lily asks, how do our freelancers apply on Friday? I'm not sure what the significance of Friday is, but.
Well, Friday's when supposedly the program is supposed to open up specifically for sole proprietors and contract employees. So they would apply the same way through their local institution using the 2483.
Our next questioner asks about the justification of need for the loan. What are the potential risks, liabilities of the SBA's requirement for certification of need? How do the SBA lenders secure sufficient backup on applicant certification on the need to be comfortable with underwriting a loan and applicant compliance with the PPP requirements? So that was the very last thing we touched on. So the question may have come in prior to our covering that. It is on the application, and I think we addressed that question. Does anyone want to add anything more than what we've already said about it? I'll answer one part of it. I don't think banks are trying to look at need. I think that they are taking the certification at face value. What do you think, Chris?
I would totally agree with that. You're signing that application. On the application, it's clear that you're certifying that the COVID-19 has affected you.
I think that where the real rubber hits the road is, let's just say you're a venture-backed company and you've received $5 million in a Series A, and that constitutes 24 months of runway on the current burn for forgetting about your future plan. Can you really say that you needed the money to preserve payroll or continue operations? That's a difficult question that companies across the country are grappling with. And the guidance that Scott, I think, gave earlier about having attorneys at the board meetings to go through and have the directors really focus on whether there's a need or not are critical. And I think the SBA may end up embarrassing funds or companies to the extent that there wasn't, that in egregious cases. But I think in most cases, they're really, in my view, they're really looking for bad faith. That if you can make out a good faith argument that the uncertainty of the economic climate jeopardizes your future operations, including ability to keep payroll where it is, I think that they're not going to really look behind that and Monday morning quarterback that. I think that you will have a lot of leeway there. I think it's really the egregious cases where you're really flush with cash and had a lot of runway to get through this downturn. That's where it's possible. We don't know for sure that the SBA may question you.
And I'd like to add one thought on that. I had a discussion with a company CEO that was in the process of applying, and I wasn't sure how to reflect on the fact that he was getting a lot of capital in from a round of capital. And I asked him, well, what is the current environment going to do? And how would that potentially impact your business plan? And his comment was that it was going to delay his ability to roll out his products because, whether it's a physical, location or other things like that. And I said, you should see guidance, but I think that would apply. So whether it's, postponing your ability to open retail branches or it's postponing your ability to roll out certain products for different reasons, In my mind, I said to him that that's probably a good enough reason for you to discuss with the board and with your advisor.
Let's also focus on what the remedy is if there is a problem on that. It's not going to be forgiven, and you're going to have to pay back that loan. So it's not free money if you don't meet those need requirements and you're audited and you fail that audit on that.
Well, let's be clear. That's one remedy. The SBA also has at its disposal directly civil penalties as fines, as well as referring it to the Department of Justice for criminal prosecution. I think those the cases would have to be extreme cases of bad faith for that to happen. But it is something, anytime you certify something to the federal government, you really want to be clear on your basis for doing that. Next question, Tim Malone, Tim. He's asking if his investor has multiple blocking rights. Are we concerned about any single blocking right being a possible affiliation, or does it require, or do you have to look at the blocking rights on an aggregate? And the list that Scott went through earlier, I think that it's possible that any one of those, if any one of those rights is in effect, any one of those protected provisions, that you could end up being an affiliate with your investor. Scott, do you want to add anything to that?
Yes, this list was derived through a number of different SBA-based cases. There wasn't this list in one case. So this was derived in situations where one or two of these have triggered affiliation concerns. So you need to be careful about each and every one of these.
So this is an interesting question from our next questioner. Have venture fund or private equity fund managers, the management codes, have they been applying for the PPP loans? Anyone know?
So the venture companies directly?
Yeah, so as opposed to their portfolio companies. So the
Yeah,
management companies have employees, just like any other business.
Well, specifically, the SBA came out with guidance through our trade association, National Association of Government Guaranteed Lenders, that says specifically venture capital companies are not eligible.
Okay, that's black and white then. I think we're getting to close to the end of our list, so let's see if we can finish it up, and we're at the top of the hour. New questioner asks, they have a startup. Their first employee was in September. They currently have 9 employees to date. How would they best represent their reality for retaining 9 individuals on payroll, as they don't have historical data going back prior to September?
I would speculate, but I think you would annualize your payroll and then do a monthly, average of that annual. I mean, that's the only way you're going to be able to fit the formula and give yourself a fair shake. I would do anyway.
Hey, Chris, the rules were pretty strict on the last 12 months or immediate 12 months and the average, but are you allowing people to just look at their annualized?
I can't say specifically that I've seen one like that, Terry. So again, this was just my thought. You could try that and send it to your lender and see what the prevailing thought there is. I'm just speculating on how you could handle it.
So this is one where we probably want to find out more over the next couple of days, but this is one where it's been very unclear, Chris. And so anything you can do to help our clients would be great.
Absolutely. I'll try to float the question, but I'll be very honest with you. The turnaround time on these questions has not been too spectacular.
Since one of the qualifications that the company had been in business since February 15th of 2020, then it's possible that shorter length companies, they didn't bring it back a year to say you had to have a year runway.
Since we're running out of time, but we'll take 2 more questions, and then we'll close it out. Lily asks if freelancers can now also qualify for, since they can qualify for unemployment benefits, what's the reporting requirement for the PPP program? Do they need to show they're continuing to work for the original companies from earlier this year?
I don't think so. It goes back on the historical basis for what they did in the last 12 months.
And our last question is from Chris. Terry, did you want to add something?
No, I agree with Chris, which is doesn't matter what they're doing, and especially if they're independent. As Chris mentioned, the website will open on Friday.
So Chris asked a question. So we've gotten several variations of this. He circles back to the question on companies that don't have payroll, but where their owners take regular distributions of profit. Would the distribution to partners going forward be considered payroll for the 75% payroll hurdle for forgiveness?
I think we touched on that, that yes, if they're paying taxes on that, then they can verify that through K-1s or, you know, year-end financials for 2019 if they had to.
So thank you. I think that does it for us. I want to say thanks to Terry and Scott for participating, and particularly Chris, who's deluged with requests for questions like this and trying to administer the program within Dogwood. Thank you so much, Chris, for being a part of this, and Terry and Scott as well. I want to reiterate that all of this is real time. We're giving the best answers we can. This is very fluid. The information we're getting is almost daily from the SBA. So these answers may change. Feel free to check in with any of us. I think you can contact Terry in particular if you have specific questions, and if they're of a legal nature, he'll channel them to one of our attorneys. If he can answer them, he will. Again, I don't think outside of someone like Chris, Terry is one of the most knowledgeable people about the PPP at this point, and we've leaned on him as attorneys greatly for helping us drill down on the program itself. With that, I want to say thanks again to all of you who listened in on this, and please stay safe, stay well, get outside, take walks, and we look forward to hearing from all of you soon.